All right. I love this. I feel like a news anchor person now. Uh, so maybe this will be news you can use. I'm going to talk about software patent litigation and what we've learned. When something, no matter how nefarious, goes on for decades, you end up with lots of data that we can look at and analyze trends from. So we're going to take a look at some of the things that have happened since we started software patent litigation and where we are today. First of all, I'm not a lawyer, and I work with some lawyers, and the ones I work with happen to be very nice. But I'm not a lawyer, which of course means that this is not legal advice. Aside from the fact that I'm not addressing you specifically, but speaking generally, you should also not consider this legal advice that you should go make expensive decisions based on. If you have a patent suit that's happening with your company, you should get an actual lawyer. I say that because you'd be surprised. Even when I was working reception, people would try and get free legal advice out of me at the Free Software Foundation. So, understandable. Legal advice is expensive. Anyway, so the big picture, in last year in the US, 2014, 300,000 new patents were granted, which is a lot, right? They're not all software patents, which I guess is kind of the good news, but somewhere between 50 and 65% of them, depending on how you classify software or software-related inventions, have something to do with technology, software, or software and business methods. So that's a lot of new patents. Why is that, you might wonder? It's not because we had 300,000 new ideas about fixing things. We identified 300,000 new problems. So in the legal profession, we call this functional claiming, but I'll break that down for you. It basically means you go to the US Patent Office and you say, I've identified a problem, and I plan to fix it with software on a computer, but don't worry, I'm not going to pester you with any source code or any code of any type. I'm just going to tell you that I have identified a problem and that I plan to fix it using software on a computer. And the US Patent Office says, well, all right, if you cover that with enough legal verbiage and some confusing diagrams, I'll give it to you. That's paraphrasing. I don't think they actually say that, but that is kind of how it shakes out. And so there's some problems with the Patent Office. One, they're sort of incentivized to grant patents, so they're more likely to grant patents than not grant them. And that number has actually been going up. It used to be hovering a little under 50%, but they're now at about a 60 to 70% granting rate with applications. They get a little bit more fees for the office when they grant patents than when they don't. So it's kind of like, they're working on commission. And they also don't get enough time to look at each individual patent. So even if they were trying to do their work, they're asked to assume that a patent application is worthy and then spend a not very long amount of time trying to figure out if there's a way to deem it as a non-worthy patent. So there's some problems there. But inventions, actual new inventions, are not one of them. Just to kind of put that in context, this is the US utility patents issued over time. So you can see how that number is going. So another couple things I thought were interesting, about 50% of those patents were given to inventors outside the US, which is interesting. I go, sometimes I leave the country and I talk to folks about software patents, and I usually get something along the lines of the question of like, man, why are you all so crazy over there? And, I have to say, like, well, I don't work for the US Patent Office. I'm like not the president. I don't really make policy. I just kind of get to talk about it. And they're like, oh, well, so you don't know. And I'm like, I don't know why. No, well, I do know why we're crazy, but it's not only us. We know that a lot of the patents issued in the US patent system are going to folks outside the US. Which brings me to the next bit. We're going to look at some of those things that are happening outside of the US. So these are software or software-related patents issued to date. And to date means from like the 70s, which is when they have digital data on lens.org. This is actually really fascinating if you end up wanting to dive really deep. But you can see this is one of those things in which we are winning here in the US. So Australia and the European Patent Office doing a valiant effort here. And China is sort of, they've just started in the last like decade to catch up on this. And typically, all of these, there would be some overlap here because all of these patents would have a sister patent in the US system. So if you were going to take out a patent in Australia, you would probably also take out the same patent in the US system. So there's some overlap there, which means that the numbers are not quite as depressing as you might think at first glance. Some other things we know that trolls are bringing about 11% of the suits in the UK on software patents. So it's pretty hard to get data on what's happening in Europe. Because for a long time they've been thinking like, oh, we don't really have a problem here and we don't really have to pay any attention to this. And so there's very little data on software patent litigation and trolling activity in Europe. But it is happening. And we think that another thing that's going on in Europe and in the UK is that because trolls got such bad publicity here in the US that when they went over to the UK, they decided to really kind of stick with more of the lowball, kind of like we send you the letter and then no one ever speaks of it again after you settle and send us a check. So, so we suspect that they've gone more that kind of activity as opposed to the outright like two giant corporations battle each other out in the courts. Another thing we know is that there are a bunch of patents that were owned by Microsoft after they acquired Nokia that were then sold to an entity called Conversant, which monetizes patents. And they have an office in Luxembourg, which is explained to me as sort of like the Delaware of Europe, where it's really easy to incorporate there and you don't get a lot of like prickly questions about what you're doing. This same entity, Conversant, has an office in East Texas and Ottawa. Now, I know what's going on in East Texas, but I don't know what's going on in Ottawa, or really most of Canada, to be fair. But these are probably mobile patents, and Microsoft sold them for $100 a pop to Conversant, as long as they get a cut of the monetization efforts. So again, we think these are mostly happening below the surface, like letters where they go out to someone and then we never speak of it again because it's been settled. And that's a condition of settling, which is common. So, and I wish I could tell you more, but without like kind of hiring private investigators, that's kind of what I've got on that. The other thing that we know is that although foreign inventors, like all of those patents that are issued to foreign inventors in the US, they do sometimes litigate on them, not as often as US patent owners, but when they do, they tend to be more successful than US patent owners. We don't know why that is. I have some suspicions it might be the accent or something, but it's for whatever reason, we know that they're more successful. And so the last thing that I'll say is that even if we figure out how to win more of the cases where you get sued for patent infringement as opposed to losing them, it still sucks to get sued because it costs a lot of money. It takes a lot of attention away from your primary business, which is not being a patent defendant, and pretty much anything else that you might want to spend your time on. Alphabetically arranging dirt in your yard, I don't know. So getting sued sucks. And the US is working really hard to export its ideas about so-called intellectual property law. I don't know if people have been following the Trans-Pacific Partnership Agreement. Yeah, okay. I've been following it, and mostly with an eye to the copyright and patent provisions. And it seeks to actually go beyond what is the current state here in the US. So it would be like 120 years after the life of the inventor for copyright, and then carrying the idea of what the scope of patentability should be back out past what many countries in the world besides the US have. So, you know, all the patents on software, all of the patents on business methods, et cetera, et cetera. I know. We could get really angry. Maybe we should do that over beer later. And then we can I don't know, call Boner or something. But the Trans-Pacific Partnership Agreement threatens to blow away some of the wins that I'm going to talk about. I don't always get to talk about wins when I talk about this issue, but so where this is right now got turned down by the House, although they're expecting it to come to a vote again. So I don't know. Maybe I will eventually get to say this one is a win. I have no idea. So that's kind of the big global picture, aggregate numbers, that type of thing. I'm going to now drill down a little bit more into like what's happening with the specific players. So when you undergo an activity for so long, like some people become expert at it and they figure out how to game the system a little bit better. And we're going to look at that next. We now know that 65% of the litigated non-practicing entity suits are software-related claims. So when we talk about trolls in general, 2/3 of the time we're talking about software patent suits or software-related claims. And so that means that trolls have figured out that their very favorite type of case to bring is a software patent case. And they have gone to great lengths to figure out how to bring more of them. So we also know a couple other things we know about trolls is that they tend to reuse the same patents over and over again. We know that the newest patents are the ones that are the most frequently litigated, either newest to their collection or newest from the U.S. Patent Office. So the massive aggregators will sue on a patent that they've just purchased or just been granted, sometimes within a week of receiving it. So the other thing that we know is that because NPEs keep using the same patents over and over again, the average age of a litigated patent from a troll is slightly older. And then lastly, the other thing that's kind of disturbing that we know about trolls is that 40% of the time they are suing users and not makers of software. So that means that they are making your customers pay and your users pay, or people that you offered software to for free pay, and they feel even less qualified than you might as a software creator to figure out what is being sued on in the letter. So they get the letter and they're like, I actually don't understand most of these words except for patent and infringement, so perhaps we should pay. And that's what they're banking on, literally banking on. So trolls are as large and ugly of a threat as they are to free and open source software, aren't even the entire story. We've been seeing the line between practicing entity and non-practicing entity get blurrier and blurrier. I talked about the Microsoft buddy conversant that is monetizing patents on their behalf for a cut. They're not the only company that's doing that. There are other companies where they had a business area that they never pursued, but they took out patents and then are bringing patents there. So they have like a troll arm on a practicing entity. And then we've also got schools that have and own patents and are working with an entity to protect the patents that the school is producing. So the line between what is a practicing entity and what's a non-practicing entity is starting to become very fuzzy. Sorry, I'm not used to having a thing stuck to my face. So all of that said, let's look at where lawyers come in. Do you guys know what contingent fee representation is? Yeah, it's a fancy word for ambulance chasing. Which, if someone did really do you wrong and you don't have money to sue them, that's the point of contingent fee legislation in our society, is that if you're poor and someone screws you over, you can still get legal representation as long as you give them a cut of whatever comes out. Sometimes that's justified, sometimes maybe whatever. But again, that's not like really my area. But we're starting to see it happen in software patent litigation, which is my area. So this means lawyers are going to patent owners and saying like, oh, you look like a person that could use more money. And I don't know how many people would be like, no, you're totally mistaken. I have way too much money already. Anyone in here? I'll just come and talk to you later. Okay. That was no one, just for the record. Okay, so and they're sort of gaming it the same way that venture capitalists with. So this is a quote, an anonymous quote from one of the big firms that is bringing a lot of these contingent fee litigation cases on software patents. They're saying even with a 40% contingent share, so that means they're going and saying, you've got a patent, we'll bring a suit on it, you'll get 60% and we'll take 40, but we need 5 million in damages to break even per case. And so they figured out that if they use a venture capitalist model, they fund 10 cases to win one, which means the one they win, they're hoping to get 50 million on. And not because the patent or the technology or whatever it is worth 50 million. You'll notice that didn't really end up in the spreadsheet at all here. It's what they need to pay for all of the other suits that they're bothering people with, so that they can make a large enough percentage, even after paying the patent owner 60%, to have lawyers around the clock working to bring suits. Yes. The other thing, so that's the large, like that's kind of, lawyers come into like kind of a tiered system. Those are the largest firms, like really big ones, that are looking for the $50 million payout. But there are small and mid firms that are having problems where they want to be able to hire more lawyers, but they don't have money. So they say like, oh, okay, we'll get some of these young folks out of school and we'll have them work on contingent fee, like over in the less fancy end of the office or whatever. And they've got plenty of lawyers to choose from, because all during the 90s and early aughts, law schools were telling students, like, a law school degree is basically a ticket to like wealth and luxury and fancy cars and awesomeness. And, these kids were undergrads. They were like, yeah, all right, cool. And even when they were like, all right, well, show me the numbers. Law schools very famously sort of misrepresented the placement of lawyers post law school by saying how many of their grads were working, but not actually describing how many of them were working as lawyers. So a lot of folks came out of law school and found that there were actually no more law jobs left. So some of the firms decided to sort of sop up this excess by letting them work on contingent fee. So that's kind of the mid-size there, where they're like, okay, well, if you can find a case that if you can find a case for a client we don't yet have, which means you have to go find the client, then you can bring that suit, and then your office can have whatever that brings in. So at that mid-level, you've got larger firms with like a contingent fee patent monetization area. And then at the very bottom level, some of the smaller firms are just, they're just doing this to kind of supplement their other income. And they'll go after a weaker defendant first. And there's 3 reasons they do that. One is to get a little money in the war chest. 2 is to make the patent look more robust, like by saying, oh, well, all these other companies rolled over on it and they didn't find any prior art. So what do you think you're going to find when we sue you? And then also sometimes to establish a venue, like say East Texas. So they do that. And then some of the other firms, they're not even looking for big payouts. They're just going for quantity over quality, just sending tons and tons and tons of letters. So this, produces lots and lots of small money, which of course adds up, and then they can go and find another patent. So even when they do get challenged, they throw that one out, and then they'll come back. They're like, oh, well, we actually had like 16 patents in that area. So like, can you just go do a little find and replace, and we'll just send the letters out with a new patent number. I imagine. I don't work for one of these places. But for the sheer volume of letters, I can't imagine they're spending any more time on it than that. So that's lawyers and others. I'm going to talk about judges and juries next, which is actually less gross than the lawyer part. So judges and juries, Yeah, this is the bit of good news that I get to share. So in the 1990s, defendants in a patent litigation suit needed to either find prior art or prove that the work was out of scope. In the 90s, the courts were extremely reluctant to say, I don't know what they're up to at the U.S. Patent Office. This should really never have been granted. The courts, is some kind of fellow feeling government functionary to government functionary where they just didn't want to say that they thought the U.S. Patent Office was wrong. So in the 90s, if you were sued for patent infringement, your best course of winning the case was to either find something that was like, whoops, it looks like you missed this thing that someone else invented a year or two before, and there was actually prior art that like you somehow missed. Oops. Or to say like, oh, well, the person bringing this suit doesn't really understand our work that well. Like they're doing this thing and we're doing this slightly different thing, which isn't infringing. And the courts would have, that would be the best way to win a suit if you were a defendant in a patent litigation suit. So that's changed a lot, actually. The numbers, and I hope they update these one day because I would love to see how this is, what's happened to this post-Bilski, post-America Invents Act. But even by 2008 and 2009, the courts started to be like, yeah, I don't really know what they're up to at the U.S. Patent and Trade Office because this should never have been granted. And that's what that's what it means when you say non-patentable subject matter. This is 54% of the suits that defendants are winning as of 2008 and 2009 are, the court saying this is not a patent that should ever have been granted. I don't know what they were thinking. Yeah. 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 Although, as you saw, we have a good, healthy supply of patents, so it'll take a while to get them all out that way. So this is at the lower court level, and then we saw this idea kind of finally bubbled up at the Supreme Court level. So the Alice versus CLS Bank ruling in 2014. This is you can't do the on a computer anymore. So this is saying that generic computer implementation is non-patentable subject matter. The Supreme Court says this. That means that if you get sued by someone and you think that their patent is non-patentable subject matter and you have a little money to go to court, that you may actually win. So that's good, right? And in fact, we saw it almost immediately confirmed at the federal circuit level. This is less than 6 months later. The federal circuit, Digitech Imaging versus Electronics for Imaging, and their case was basically, if you have a file that can be turned into an image, we have the patent on that. That was the case. For folks that are not versed in the way that the courts like to word things, this is a giant fruit basket and like a dozen red roses. Like, thank you so much. I can finally throw this garbage out of my court. And so in their opinion, they've said like, yes, fundamental concepts by themselves, not patentable subject matter, like go home and do not let the door hit you on the butt on the way out. So we've actually started to see this reconfirmed also at the lower court level, this particular doctrine, the on a computer. So this year, no major cases, just small local ones. Some of the things that I thought were fun that got tossed out at the lower court level were picture menus to choose food on a computer. Court was able to say no. Upselling on a computer, also no. And then and the decision there actually says like, this one's probably about as old as commerce itself. So no. And bingo playing on a computer is also no longer patentable by virtue of being on a computer. So you guys can go to Grubhub, upsell, play bingo, and not worry about patent infringement anymore, more or less. Again, I'm not a lawyer. But the other doctrine that we've started to see percolate up is what what lawyers call indefiniteness. And this is when a patent has been worded so confusingly that no person who is skilled in the art could replicate the invention because they don't know what you're talking about. Once you kind of take the legalese off some of these things, it's kind of, I don't know, like some sort of sadistic cartoon almost. The Supreme Court also used this in 2014, the Nautilus versus Biosig ruling. Vague patents aren't enforceable. That's the TLDR. This case was 2 exercise machines, and because the patent holder didn't want to say hand-shaped things, hand width apart on like a exercise machine, you know, in the place where you put your hands, like they didn't want to say that that's what they were doing. They said mounted in a spaced relationship. And the courts were like, you mean hand size, like hand width apart? Like, no, you can't have a patent on that. And so I haven't seen too much from lower courts on this, but we'll probably also see this doctrine taken up and used as well. Although vague is maybe more difficult to, it's not quite as low-hanging fruit because it means you have to actually try to read these terrible patents to overturn them. So that's the good news. The courts in the U.S. have embraced we don't know what they're up to at the USPTO, but we're not going to just accept everything that they send us and rubber stamp it in our courtroom. So that's great, right? There's also been a conversation amongst judges kind of looking at the idea of like who hears patent suits. And does that make the judges who hear patent suits all the time uniquely qualified as a specialized sort of court? Or does it produce some, I love the very nice way of saying this, tunnel vision, where they've maybe lost a bit of perspective on the subject matter? And so one piece of the American Invents Act said like, well, we'll allow other judges to occasionally hear patent suits, just to see what happens. And they did. And it's not tons, but they did already find some fairly interesting data. What they found was basically that more experience with patent suits makes a judge less likely to rule for patent holders. I imagine even just one suit versus a second suit. So imagine it goes like something like this, where a judge comes into work and oh my gosh, the person who invented the internet is bringing a suit in their court. Like, how exciting. They've met the person who invented the internet. And they, you know, lots of legalese, and like the judge is like, yeah, the internet's important. So yeah, okay. And then a few months go by and the person who invented the internet is another person now, and they're back in their court and they're like, wait a second. I've heard all these confusing technical words before, and you can't all have invented the internet. So no. So even the second case, and I love the academic paper that this comes from is, does familiarity breed contempt amongst judges deciding patent cases? And I think the answer is yes. And then we have finally found someone we like when they're angry, which is good. And they're not the only ones. We've found some other folks that we like when they get angry. In New York, the Attorney General, Eric Schneiderman, had to deal with a notorious troll, MPHJ, which was pestering folks, businesses all over New York State with scanner patents. And these are, I mean, it was like copiers, fax machines, like, so they were going after people who were using copiers or fax machines or had any kind of digital imaging sort of component in their office, and saying they needed to pay them $1,000 or some number of dollars per user. And the New York AG said, no. Not only that, like, I'm suing you for fraud and I want you to pay back all the money. So that's pretty awesome. Vermont also decided, like, yeah, no. The same troll, MPHJ, was suing everyone who had a scanner or copier in their state as well, and went after a nonprofit that helps people with disabilities find jobs. So people were coming in and making copies of their resume on the copier, and they wanted $1,000 per user of the copier from a nonprofit that helps people with disabilities find work. And Vermont said, yeah, okay, as long as you were kind of, you know, like, you can't sue people with disabilities here. Like, without this, you've now stepped over from like questionable to evil, and we're not down with that. And so that was, so they're being sued for violating the Vermont Consumer Protection Act. So we are starting to see some backlash against egregious litigation and vague patents and trolls and that type of thing. So that's all good. So judges, attorney generals, like, yay, we've gotten them up to speed and they know what's going on. Not so with juries. So I mentioned East Texas before. It's sort of this notorious district where patent trolls like to bring their suits, right? It's jurors are special. They're farmers. They don't use a lot of technology. And there's maybe not all that much going on in Marshall, Texas, like where you get paid for a free lunch and get to hang out and meet people. I don't know. And so the jurors in East Texas are very patent litigation friendly in some way. This is actually so well known. I don't know how many of you guys watch John Oliver, but he did a segment on patent trolls, and went to the Marshall, Texas courthouse, and there's a huge ice skating rink that was paid for by Samsung in front of the Marshall, Texas courthouse. Like, it's got Samsung plastered on it in giant, like, huge letters, and I mean, I don't know how many people are doing that much ice skating in Marshall, Texas. They're definitely trying to buy some fellow feeling, goodwill, etc. On the way into the courthouse there. So like I said, juries are not the same as judges. Judges tend to rule for the patentee only about half the time, even Texas judges, actually. Whereas jurors rule for the patentee over 2/3 of the time. So if you, as a patent litigant, go before the court, you are always going to ask if you can have your case heard by a jury. That's just what the plaintiff does. They always do it. And because the jury is just going to be more favorable to them. So now we're at a situation where over 70% of patent cases are heard by juries. That's a huge change from like 30 or 40 years ago, where that number was about 5%. So the courts, in many ways, obvious and less obvious, favors the frequent litigator. If you're in there every week, you know what the judge likes to hear. You know how to get a jury case instead of a judge case. You know probably where all the bodies are buried, and probably where to rent ice skates, which is weird too. But anyway, the courts favor the frequent litigator. It's not about merit; it's about money. So. I'm sorry, I said this was going to be the good news part. But all right, so some things are working. Some things are working. In countries outside the US, we've seen Germany, New Zealand, and India have put really strict limits on patentability. So they will still have some largely hardware, but with a little bit of software component patent, maybe. They're not perfect pieces of legislation, but some of the more egregious, like, you know, bingo, comma, on a computer, like, they're not having it here in Germany or New Zealand or India. So that's exciting. I mean, sometimes democracy works. Hooray! One of the reasons that I was going to say, with the caveat that it works better in a smaller place than a larger place. So for New Zealand in particular, you might think like, oh, New Zealand, like maybe they could pass something similar in Australia. And I've talked to folks in both, and they're like, nah. New Zealand's sort of this like hippie surfer wonderland with like really small districts, and we have really good access to our politicians. And so we were able to get things going like, yeah, let's just not have patents on software anymore. Australia, not so much, and probably more analogous to the US. Although we have been seeing state level changes that are good. we won't see, we won't be able to remove software from the scope of patentability state by state. That's not a state issue, it's a federal issue. But you can pass legislation saying that if you are going to bring patent legislation, you have to disclose the real party in interest, like not just give me the shell corporation that you're pretending to be today, but tell me who's actually financially benefiting from this piece of, this lawsuit. You have to actually say the patents that you're suing on. In all of the blank states, that's not the case. And you have to say what thing it is you think that the defendant is doing that is infringing on your patent. So those are helpful, and probably the best progress we could hope for at the state level. So these are and these are ongoing different places. You'll notice that Texas has not signed in. Not that I'm, we haven't done anything in Massachusetts where I live either, and California certainly has some interest in maybe curbing frivolous patent suits, but has also not done anything. So they might be too big. Were you going to say something? Oh, so do software patents age out like medicine patents? Yes, they do. And in fact, they're all patents have a term of 20 years. So there is there is an academic conversation happening as to whether we should decouple the different areas of patents, because to be honest, taking on big pharma and big tech at the same time is sort of, I don't know, it's like picking a fight with a tiger when you're being mauled by a bear already. So so decoupling the term length for patents could be advantageous, but I think most politicians are afraid to do that because it would sort of open a whole can of worms. And I spoke to someone who was who thought that in fact they thought that pharma might use that as a wedge to increase the term for pharmaceutical patents. And please don't decouple all the things, because that would be really terrible for them. Yeah, exactly. Unintended consequences. And I don't know if that's the case. But we'd certainly need some fine-grained understanding of the patent system in Congress before we could consider such a thing. Right. So on the topic of them aging out, the term is very long. 20 years is very long, and also vague patents don't really help anyone, because there are numerous examples of people using a really old patent. I think there was one that was intended for music on a server being deployed to a consumer point. And what they had meant was these things in the 80s where you would go to a kiosk and you would punch up some songs and it would make a mixtape for you immediately. But someone bought it and decided to try, I think they tried to sue iTunes, which I don't remember how that one turned out. I just, the ridiculousness of using the mixtape kiosk patent to sue iTunes is so hilarious, in the worst way possible. But there are tons of those. There's other ones where communicating remotely, and then they've gone after people with a podcast, and so yeah, it points out two important flaws with the patent system for software, in that yes, the term is very long, and then two, that broad, vaguely worded patents can be misused and appropriated for technology they weren't intended for. I just have a couple more slides, and then we can open it up for questions and stuff. Some of the other things that were good, the America Invents Act said no more joinder. So previously, patent litigants had to they could send one letter to 50 different defendants and sue them all under the same patent at once. And this is one of the reasons that they were able to make a case for East Texas, because they're in the middle. So we can all meet there instead of anywhere that people want to go. or where your business is located. I mean, it adds cost for your California defendants. It adds cost for East Coast defendants, and it just makes it more annoying and more likely that they'll want to settle. In addition to having this very favorable district when they do get there. This had like some limited effectiveness. You can see when the American Invention Act came into effect, there's a little dip on the number of parties involved in non-practicing entity lawsuits, and then it starts to go back up again. So they figured out how to send separate letters. I work at the Open Invention Network, which is a mutual non-aggression pact. We work just for the community of free and open source software. So like Linux, GNU, Android, a lot of the development tools and things that would come with a GNU Linux distribution or on a mobile device is covered under the mutual non-aggression pact. So basically, we ask everyone to sign something saying like, I promise not to sue anyone else who signed this thing. And we have about 1,200 Flask companies and projects that have agreed to not sue each other, which is great. They also offer a free cross license to all their patents to each other so that if you get sued from outside the pool, you have something to countersue with. Again, with the caveat that suing is expensive, countersuing is expensive. We do also coordinate some defensive publishing around key stuff around, Linux, Android, GNU that we think is particularly juicy looking litigation areas. So that's another thing that we do. So your homework, if you've decided that you would like to do something about this, patent busting, this is great. You do not have to be a lawyer. You just have to understand the technology. I saw one come up on, I think it was on our site, the linuxdefenders.org, where it was Microsoft just a couple years ago was trying to get a patent for the amazing invention by which alerts you to having forgotten to put an attachment on your email. So you know how like when you write an email and you write it's attached, and then you actually forget to attach it because you were doing something or you knocked your coffee over or whatever. And then you get a little box that says like, oops, it looks like you forgot to attach your file. And so just like 2 years ago, Microsoft had filed a patent for that invention. I assume everyone here has been emailing for more than 2 years and has seen that little box, right? Yeah. So if you pay even a little attention to technology, you can participate in patent busting. Maybe you have a screenshot from 3 years ago. You could help. Pass laws if you can in your state, like the one I talked about, disclosing the real party and interest, asking the patent litigants expressly say what patent they're suing on and what activity they think the defendant is engaging in that infringes on their patents, with the recognition that passing laws is sort of like making sausage. But maybe you can ask some friends from a neighboring state to help you navigate that process. Lastly, keep talking to your neighbors and colleagues. Most people heard the NPR suit and they're like, oh, trolls, that sounds so terrible. Or they hear about like Samsung or Google or Apple, and they don't really understand that, nonprofits are being sued, and like small businesses and individuals and like tiny software projects are also being sued. Because I know that occasionally when I talk to people about patent litigation, they're like, I honestly don't care if Samsung and Google sue each other out of existence. Like, I have the tiniest violin for like the millions of dollars going back and forth between those two companies. I'm like, yeah, no, I understand that, okay? But, it's, but talking to your neighbors and colleagues and letting them know that that's not the only place that this is happening. And if you want, you can also tell them that's making their phone more expensive. So if you really need to bring it home, if you enjoy reading about this stuff, like maybe you feel too optimistic and sunny about the world sometimes, and you like to read stuff that will fix that. There's lots of stuff, and I have more of these. I've read probably like more than 100 of these by now. But this one is the one that's the only place where I was able to find some information on Europe and non-practicing entities. The one about the patent term reduction the gentleman in the yellow, you in particular may enjoy this one, from talking about how patent term reduction might fix the troll problem. It might not. He leaves it a little bit inconclusive. The contingent fee representation in patent litigation, if you want basically a lot of anonymous quotes from sociopaths, that's got you hooked up. And then does familiarity breed contempt among judges deciding patent cases? I already told you the answer is yes, but the tone of this one is pretty entertaining. And then understanding the realities of modern patent litigation. So if you enjoyed the part where I talked about the different doctrines, like where the courts went from not wanting to throw the USPTO under the bus to being like, I have no idea what you guys are up to over there, but it's not, I'm not having it in my courtroom. So there's that, and then there's a lot of data at lens.org too. I of course have pictures and font credits, and I would be willing to take your questions. Thanks so much. All right, I'm gonna go to the gray in the back because we did hear from you once already. Prenda La? Okay, yeah, postage is cheap. Thousands of letters. Uh-huh. Yeah. Yeah, so the shell companies, that's actually a pretty well-known phenomenon. There's another great paper that I didn't include there called the Giants Among Us, which is about massive aggregators and talks primarily about intellectual ventures. But there are a lot of other companies that thought, that Nathan Myhrvold guy has a ton of money and I want a ton of money. So they have borrowed a page from that and also done the Shell Corporation thing. And that's why those states have passed legislation saying, like, you must disclose the real party in interest. You cannot hide behind like 7 layers of shell corporations. Like, if you're going to bring a patent suit, then you have to tell us who really owns the patent and who's really going to get paid. So yeah, so that is definitely a trend, and that's why the response in the form of the statewide legislation has happened. Uh-huh. Oh, great. Yay. All right, so another troll that was bringing suits on serving adult content, which is, again, probably as old as commerce itself, has been served with contempt on a computer, of course. In the back. Sure. Yeah. Sorry. So these are statewide legislation. I'm saying the current default is not to actually say what patent you're suing on. Yeah, it runs. It. Have you seen like Goodfellas? Yeah. So it's kind of like, I've got a lot of patents. Sure would be a shame if we had to do something to this nice business of yours. F you. Yeah. I mean, I don't know. I don't know how you would render the knuckle cracking in text, but it is basically like, we're a company that has a lot of patents in this vague area, and it seems that you're infringing some of them. And so, like, they may ask for a specific fee, or they may ask them to enter into a cross-licensing agreement with them. And then once they've signed, they'll see what the patents are, maybe. There's a lot of weird ways. There's actually like a great story of a Russian inventor who got a letter from a U.S. NPE that, like, he got one letter that was like, hey, we've got a lot of patents. It seems like they'd be really helpful for your business. Maybe you should enter into a cross-licensing agreement. And then they got a letter from a slightly different entity saying, it looks like you're infringing on all of our patents in this area. And then, and he ignored them both because he's in Russia. He figured, like, how are you going to get me over here? And then he got the other letter saying, like, hey, are you sure you don't want to do a cross-licensing agreement? So he contacted the U.S. government, I forget which agency, and asked if he could bring a racketeering charge against the entities sending the letters. Sadly, they said no. It's actually completely legal to have a big, pile of shell corporations and send conflicting, weird, vaguely threatening letters. Yeah. Right here. Oh, so the question is about the state legislation. It varies a little bit from state to state, but basically it says you must explicitly say which patent you think is being infringed that you own in your letter in your initial letter, and that you also must say what activity the defendant is engaging in that you believe infringes your patent. Yeah, you actually have to send letters to people whose businesses you're at least a tiny bit familiar with, and name a specific patent that you own. Yes. So, yeah, yeah. Yeah, in the right. So that what you've gotten to the heart, he's asking about how software patents are different from mechanical patents, and the answer is there that it makes notice particularly hard because so if I invent a pitchfork and then you invent a pitchfork, like, everyone in this room can just look at the two pitchforks and we know if it's different or not. But for a software patent, you say, like, oh, I'm fixing this problem, but you don't have to provide the code. You just have to explain your method, which, like, isn't even actually as robust as providing pseudocode. It's really it's very different. And I guess if you were to do a diagram, you might draw a picture of a computer. Mm-hmm. Yeah. Right. Yeah, so a thing that you may also find interesting is the context-free patent art Tumblr, which shows. So it's a fellow who works in the gaming industry, and he has to look at patents for his company in the gaming industry area, and so he's got maybe like 500 different images of diagrams that are supposed to accompany the software underlying a game that some company has asked for a patent on, and they're pretty ridiculous. You can see, like, where there's that one's good because it's context free, so you don't really know what the patent is, so you don't endanger yourself as far as triple indemnity. And he's really cherry picked some of the most ridiculous ones. But there's like one where it's like a dog, and it's like yes, no, like with word bubbles, and it's like something about like how dogs behave in game or whatever. But so they do still include diagrams. It's not the same standard because it is abstract. There's like kind of this whole history of patents becoming more and more abstract. So like they were originally very mechanical, and then kind of pharma is like chemical. Like you can see it if you had a microscope, and then business method patents are like, oh, it's kind of it's a feeling or a flavor or something. And then you get to like like math on a computer with some things and, sparkles. Well, that's it's a design patent, which is definitely not my wheelhouse. Does anyone else have a question? Because I can talk with folks out in the hallway too, if we're just, down to, uh, gossiping about silly patents. Anyone? Okay, great. Thank you so much.
Your customers rely on your website or application. If it's slow or non-responsive, it infuriates your users and costs you money. Keeping your business-critical systems humming along requires insight into what they're doing. Your system metrics tell stories that can reveal performance bottlenecks, resource limitations, and other problems. But how do you keep an eye on all of your system's performance metrics in real time and record this data for later analysis? Enter Longview, the new way to see what's really going on under the hood. The Longview dashboard lets you visualize the status of all your systems, providing you with a bird's-eye view of your entire fleet. You can sort by CPU, memory, swap, processes load, and network usage. Click a specific system to access its individual dashboard, then click and drag to zoom in on choke points and get more detail. Comprehensive network data, including inbound and outbound traffic, is available on the Network tab, and disk writes and free space on the Disks tab, while the Process Explorer displays usage statistics for individual processes. The System Info tab shows listening services, active connections, and available updates. Adding Longview to a system is easy. Just click the button, copy the one-line installation command, then run the command on your Linux system to complete the process. The agent will begin collecting data and sending it to Longview. Then the graphs start rolling. Use Longview to gain visibility into your servers, so when your website or app heats up, it stays up.
Citrix Zen Server gives you everything you need to integrate, manage, and automate a virtual data center, all on an enterprise-class, cloud-proven virtual platform, and at a third of the cost of other solutions. But why even bother with virtualizing your server infrastructure in the first place? Well, let's say you have a traditional one server to one application architecture, but you're running out of resources and performance is suffering. Once you order new server hardware, you'll wait for delivery, configure it, install your business application, stage and test the server, and finally, add it to your production farm. If you've been through this process before, you know it can take weeks or even months. You also know it's a manually intensive process that will burden your team every time you outgrow your current setup. With a virtual server solution, you could accomplish all of that in less than half a day. Server virtualization software separates the OS and application from the underlying server hardware. And with multiple virtual machines on a single server, you can use each of them to run different OSs and applications. This makes it possible to move your virtual machines from one piece of hardware to another whenever you want, to maximize utilization, simplify maintenance, or recover from a hardware failure, and without slowing down your applications or users. Clearly, server virtualization provides big benefits, and Citrix Zen Server provides even more. Since it's built on an open platform, Zen Server plays well with your existing hardware, storage systems, and IT management software, as well as with the industry's leading cloud service providers. Best of all, you can get started by downloading a fully functional, production-ready version of Zen Server for free. After a 10-minute installation process, you'll see how easy it is to start virtualizing your workloads and automating your IT management processes. And when you're ready for a richer set of management tools, just upgrade to one of the premium editions of Zen Server. So whether you're interested in virtualizing servers for the first time, expanding your server virtualization footprint, or moving server workloads to the cloud. Download and install Zen Server today and see how it can help you simplify your IT environment. Citrix Zen Server. Do more. Don't spend more.